representing herself and will submit argument. The respondent apparently is not going to appear today.
Good morning, Chief Justice and members of the court. May it please the court, I am Mary Pandria, representing myself pro se today in this matter. I am only requesting that each parcel have one easement only, and to do otherwise would be greatly prejudicial. All of this property was part of my parents' trust. And that was purchased in 1991 by Mrs. Carrie Clark. With this purchase, a deed was recorded, number 396781. As a part of the deed, there is an easement which is described as on the existing road, and it goes with this property and is subject to. And it was a road that's existed since the 1950s. And many of these parcels that were sold, and this, including this property, which is one of Carrie Clark's parcels, also enjoy an easement over this roadway. Judge Luster created a new roadway across the parcel that was partitioned to me. This new roadway goes from the center of my little bridge here and goes northward all through my property to the north end of my property. It's 10 feet wide. It passes within 8 feet of my woodshed. It passes within about 20 feet of my house, 8 feet of my caretaker. It's not an easement. It's very partial to me. It's very prejudicial. Judge Luster abused his discretion when he denied my request to remove the 10-foot wide road that he created over my parcel. There are 4 standards in particular that should have been considered in defining great prejudice that apply to this case. The first one is whether or not the partition in kind would vitiate the county building and zoning codes of Bonner County. And this did. And lastly, whether or not I was harmed by the resulting partition, since I no longer had a right to privacy or a way to secure my property. These are all standards that I have argued repeatedly throughout this litigation. They should have been considered in the partition. Judge Luster did not properly apply these standards, and I was greatly prejudiced. I respectfully request that this court correct this error by reversing Judge Luster's denial of my motion, eliminating that second 10-foot roadway across my parcel 1